Good morning and welcome to all. My name is G. Chatterjee.
And I'm Kumari Haripriya. And today we are the anchor of this event. One of the key highlights of our event is the Expert for Mentorship Support session. So one of the key highlights of our event is the Expert for Mentorship Support session, where participants will get the opportunity to gain insight from experienced professionals.
Now we would request to our Honorable Pro Vice Chancellor, Accreditation Research and Advanced Studies, Sir, to please address us. Now we would request to our Honorable Pro Vice Chancellor, Accreditation Research and Advanced Studies, Sir, to please kindly address us.
Good afternoon, everybody, and especially welcome today's speaker, Advocate Manisha Mishra. In fact, it is a great pleasure that when I spoke with a, I could understand is very enthusiastic about the subject that is IPR, and because of did her LLB from Indian Institute of Technology, Kharagpur, from Rajiv Gandhi School of Intellectual Property Law. So, and when I requested her to speak to us, I mean, she readily agreed, and I am very, very thankful to her for this. And I look forward to listen to a wonderful discourse, as I know she not only was good in education and academics, but also she is a practitioner and she has handled IPR prosecution, and she is also a patent agent, and she has the experience of remaining a patent attorney. So who can be a better speaker than this for today's session? And since we are a bit delayed, I won't prolong my discussion further. So I would request the speaker to please start our presentation. I welcome once again.
Thank you, Professor Dan. Good afternoon, everyone. I firstly would like to thank everyone and CCOM Skills University for giving me this opportunity to speak on this topic. Thank you, Professor Dan, to ask me for discussing this topic. I'm more than interested in discussing on the basics of IPR and especially for innovators and startups. When we were students, we used to hate that Newton used to increase our syllabus. And we used to always think, why the hell did apple fall on his head? So we wish that the apple didn't fall on his head. And now I'm given to understand that all of you students, all the attendees of this session are on a vacation, and I've been asked to, have been asked to attend this session, that too at this afternoon time, just after lunch. And it is a really big challenge to listen to heavy topics like startups, inventions, and IPR while you are on vacations. पर अब क्या करें, देश को विकास चाहिए और उम्मीद ये सब आपसे रखते हैं. I would be glad if you guys can interact so that this doesn't become a one-way monologue session. So if there is, in case you have doubts on anything, then you can put on the chat, and at the end of the session, I can take the questions for you. And I will keep my session mostly in English. I hope that's a convenient language medium for everyone. And before I start, can you just let me know that all of whatever I'm saying and I am audible and visible for all of you? Just, I think if you can raise your hands in the chat box or something, I think that will confirm. Am I audible?
Yes, ma'am.
Okay, thank you. So I will try to make this session as interesting and informative as possible so that you guys won't curse me for disturbing your sleep. But if you did not sleep right now, you might be seeing dreams. So my objective right now here is to still continue with your dreams, just with your eyes open. Because as Kalam sir said, best dreams are those that don't let you sleep. So before we jump into the buzzwords, I would like to know if any of you, while sleeping or you had dreams, you got some eureka moments or some ideas. If anyone can answer, like all of us do get a lot of ideas. Okay, I'll continue. But those of you who have not, who don't get ideas, please don't lie to yourselves, because you definitely have heard of the jugaad and you must have done some jugaad to solve your own problems. So maybe the next slide will help you see, like the next slide, can someone shift to the next slide? Okay. It's just something of my personal experience. When we were in hostel, we 5 friends were allotted a dormitory which did not have cupboards. It had beds, it had bookshelves, but it did not have cupboards to keep clothes. It was very difficult for us to keep our clothes in the suitcases or trolleys and use them daily, especially when it was you had only 15 minutes to go and attend the classes. So in that case, yes, in that case, we just thought, like, how could we get a solution to our problem? And then we saw that there was an extra table in our room. Now what we did is we inverted the table, and the rod that was joining the connecting rod, the supporting beam of the table which connected the legs, we thought that could be used as a hanger for clothes. So that was our jugaad. But if even I was given money for buying this, I won't buy this for myself right now also, right? So, but it was an idea, and it was a novel. It may not be a novel thing, but there was something. It really did solve a problem, right? Can we move to the next slide? Yeah. So today in our discussion today, we will discuss what is an idea, what is an invention, what is an innovation, what are the differences between these three, what is property, and what is the difference between property and intellectual property, what are the types of intellectual property, and what are the rights in these intellectual property involved. Okay, so can we move to the next slide?
Yes, ma'am.
Yes. So what is an idea? Idea is a concept or thought that comes to your mind, right? But it stays in the mind. Nobody can know what you thought of, but it is an idea. It's the bedrock of all innovations. Without an idea, we cannot reach to the stage of innovation. What is an invention? Invention is a new solution to a technical problem. So if there's a problem, you have an idea how to solve it, and there is a physical form of solving the problem, right? And what is innovation? Like, you have an invention, but can it be commercialized without, is there a demand of that product or service? That so innovation is known as invention into commercialization. Now, many of you will ask, might think that why is it into commercialization, or why is it a multiplication? Why is invention multiplied by commercialization? Because if there is no invention, then even if there's a commercialization, we still don't have innovation. But if we have invention and there is no commercialization, we will still have no innovation, right? So that's how the formula is. I'll just explain it to you with the help of an example. In 1830s, Robert Anderson thought that cars could also run on clean energy and not fuel. And he invented an electric cars in between 1832 to 1839. But until and unless Tesla electric cars came, so that was a very slow, short-ranged thought or an invention which was forgotten. But Tesla revived Anderson's idea by fusing cutting-edge battery technology, speed, and style, for which now we can have electric cars, and it has gone to the extent of driverless cars also. So I hope you understand the difference between idea, invention, and innovation. Please raise your hands if there's any doubt. Okay, I'll move to the next slide.
Okay, ma'am.
So what I said to you about Tesla was something foreign. Let us see the Indian journeys of idea to innovation, our own stories. Ola Cabs was founded in 2010 by Bhavish Agarwal when he missed a cab in the rain and got stranded, and thought India needs a reliable rides at the tap of a button. And hence came Ola Cabs. What was the problem? It was an unreliable cab service, and the innovation was an online cab booking platform. Similarly, with Swiggy, Sriharsha Majeti and Nandan Reddy, they saw how hard it was to get good food delivered, and thought that why not build a seamless platform to connect restaurants. And so the problem of disorganized food delivery was solved by the delivery platform called Swiggy that we all know now, and it's our favorite. I think Swiggy has reached places that we can't even think of. Some more stories. Can we have the next slide? Yes. Yes. So, Flipkart. It was founded by, everyone knows Sachin Bansal and Binny Bansal. But why did Flipkart come into being? It was because they could not buy books online and couldn't find a reliable site in India. So they built one which they started in their own apartment. Similarly, Nykaa, Falguni Nair, she retired as a banker and started Nykaa to create a beauty platform which focused on online store at the age of 50. So we understand that for businesses or startups or entrepreneurship, you need an idea which leads to innovation. And that's all you require. Age is not a bar. There's no bar to you know setting up your idea to fly into innovation, right? So, but all of these have something in common, right? The idea to innovation part. What is idea? Where does idea come from? It comes from your own mind. So it's a creation of the brain or creation of your mind. Unlike properties like a car, uh, you can't see it. It is not a tangible property, right? Your idea is not a tangible property, and idea can come to anyone. Today, Bhavish Agarwal sat in a cab and thought of the idea. What if he didn't work on it? Somebody else could have had the same idea. Maybe many were having the same problems. The idea may have come to few more, but Ola was created by only Bhavish Agarwal, right? So, because he tried to solve the problem and it executed it in some form of tangible form. We cannot have any kind of right over something. Like suppose I tell an idea to you people today. I think of a flying car idea. But after telling that, it can come to you also. And you can develop your own flying cars. And then I cannot stop you from making the flying car. So ideas cannot be protected. That is the basic of this. Ideas cannot be protected. But without ideas, we cannot go to innovation. Can we have the next slide?
Yes, ma'am.
So, what is the requirement of protection of an intellectual property? So, what is intellectual property? It is the protection of the. It is a property which is created out of your mind. It is a creation of minds. It can be in the form of art, literature, inventions in the scientific domain. So all these are intellectual property. I'll come to the types of intellectual property later. But then you'll think, yeah, what is the requirement of intellectual property and why does it need protection at all? Right. So just think, you plant a mango tree in your garden. You dig the hole. You plant the seed. You water it and wait for a long time. And finally the tree grows and mangoes appear. Now tell me, who do the mangoes belong to? Because you have put that labor into it, then now you have worked hard for it. So when you have put an effort into something, the mangoes are yours. You own the mangoes. But in case of mangoes, you can see that there is something growing, you can feel it, there is some tangible value to it. Suppose you are an app developer, right? So what happens is you, or a software developer, you spend weeks writing the code. What you do is you don't go for class, you don't attend classes, or you don't, you don't do regular jobs, but you sit to develop something new. You try to solve some problem with your software. You have put in time, effort, and your creativity. Shouldn't it have some value? Shouldn't it have some reward? And that is why intellectual property requires protection. Okay. So yes, let's move on to the next slide. Now, how is an intellectual property different from your property? You can see the two pictures on the two sides and you can understand that car you can see. So that is a property. That's a tangible property. Intellectual property is a creation of your mind. You can see the flying car inside inside a human brain. So property, in general sense, is tangible. It can be tangible and intangible. So intellectual property is also a form of property. This intellectual property is intangible and it is a creation of mind, while property in the general sense is tangible, which are physical assets. Now, property can be like tangible property can be movable property like land, movable property like cars and jewelry, and immovable property like land or buildings. Intellectual property, what are the types? Patents, trademarks, copyright, designs are only a few of the intellectual property. There are there's a long list of intellectual property. How do you own a property in general? You either purchase or get it through inheritance, right? There's a transfer of that physical asset. Similarly, in intellectual property, you first you create. In property, that you cannot create a property. Okay, like yes, a car is created and all of that, but you get the car as it is after it is manufactured. With intellectual property, if it is, but the person who has created a car, like suppose for Mercedes-Benz has created a new model of the car. The intellectual property of you can own the Mercedes-Benz, but you don't own the intellectual property of it. You cannot modify it and sell it to someone else because you don't have the intellectual property. So how do it is acquired through creation, innovation, and legal registration. So certain intellectual properties require registration, certain intellectual properties do not require registration. Okay. So, and when you own a property, you own it for an unlimited period of time unless you transfer it. With intellectual property, it is limited by law. Now the question is, why is it limited by law, right? So for understanding that, we'll move to the next slide. So yeah. So how IP works is that when you create something like an app, a book, or even a medicine, you spend time, money, brain power. So without protection, anyone can take that from you. So we need to protect it. So, like, what will be the problem if there is no protection? Your competitors can copy your idea, or those ex-employees who have worked under you can leak the same idea. Once it is out in the market, people can reverse engineer how you got to that idea or that innovation. And once you show it to all, it is free for all. So now, why do we need IP? Is you require it as a law. You need to, like, you have a key for your car, you lock your doors, there is a property, you have property papers for your land, right? So there are boundaries in the land that you protect, that this area is only yours, right? But the trade-off with intellectual property is, if, like, suppose you invent something and you have a monopoly over it, and it is for an unlimited period of time till you die, then nobody can, the point of intellectual property and giving reward for intellectual property is that it's a creation of your mind. You do something innovative, you are rewarded for your innovation. But if it stops at you, then no one else will get the benefit of reusing it. Like suppose the same thing. Suppose Robert Anderson built the electric car, and Tesla did not have access to how it was built. Then it would be difficult for Tesla to do anything new and modify and get it to the people. So the development will stop if intellectual property is restricted and monopolized. That trade-off is managed with the help of expiry period, exclusive licensing, and all of that. So the major objective of intellectual property is that you are rewarded for your innovation, but at the same time, others also get to improve on that innovation. Others get to know the benefits of such innovations. So it is useful for the society. Okay? Okay. So just let's move on to the next slide. Let's go to, so this is what I was trying to explain, that IP justification and IP limitations. Right? Okay, let's move on to the next slide. We'll discuss the types of intellectual property. Yes. So these are the few types of intellectual property that has been listed here. There are many more. So what are they? Patents, which is for inventions. Copyright is for creative works. Trademarks is your brand's identity. Trade secrets is suppose you have a special recipe, but it cannot be protected under any of the other intellectual property. Recipe is something that you know, it's just a knowledge, right? And trade secrets are not something that is legally protected in India. It does not have a strong legal protection in India. Okay, then we come to designs, industrial designs, like the design of a car, fabrication design um, of some electronics product. And then there is geographical indications where certain products are tied to the place. Suppose like Darjeeling tea or Mysore silk. And then there's traditional knowledge, like ancient wisdom, which has been protected for the, which has been needs to be protected for the future. There are other things like plant variety and everything, but I will today concentrate on only patents, copyrights, and trademark. Right? So let's move on to the next slide. Yeah. So what are patents? Does anyone have any idea on what are patents? Like before I start discussing, you must have heard about it a lot of time. If anyone can answer.
Madam, patent means any design, any idea, all of this.
Okay. Anyone else? So when you say patent means any design or any idea, again I said all of these are different categories. An idea cannot be patented. So idea can neither be patented nor copyrighted. It cannot be protected, as I said earlier, right? What is patent is it protects the invention. It only um, patent. What is a patent? When I say it is a legal document which describes an invention, and what it does is it grants a legal protection of your rights. So of the inventor's right. You all of you must have seen a property paper where it says like what is the area of your property. Like when there's a sale transaction, everyone must have seen that there is a when you buy a property or an apartment, there's a clear description of what that apartment is, what is the property. Even when there's a sale of car, you have a clear description of what is the color of the car, what is the model of the car, what is the name of the car. Those are the documents that give you the proof or the ownership, proof of ownership of that property. Similarly, patents give you that right that this is your invention. This is the invention. What is the criteria for patentability? What all you can patent? Basically, as we heard, I mean, as I told you earlier, patents are related to inventions, and inventions are something that solve a problem. So, and patents are granted on three conditions. One, it must be novel, it must be new. That means it must not have been done before. It does something like that, does that particular solution to that problem does not exist before. What is an then it must have an inventive step. That is, it is non-obvious for the state of art. Okay. So like I gave you the example of that jugaad that I did. That is something which will come to anyone's mind, because what happens is that you need a rod to hang clothes. That is very obvious that you can do. So there is nothing inventive about it. So if a person in the state of the art does not cannot think of that solution that you came up in ordinary terms, that is where you have an inventive step. Now, novelty is done, inventive is done. But what if it does not come into use in the practical scale? For example, that table that I said, can you use that table for hanging clothes on a regular basis? Will anyone buy? I won't buy also. So that is the patentability criteria. Okay. So what is the purpose of granting patent? Is that it encourages the innovation by offering exclusive rights. It rewards the inventor for public disclosure. This public disclosure is very important. Like suppose you can invent and then you keep it to yourself so that the other persons do not know. Then where the development will not happen for public in general. Only because we have had like uh, from wheels to cars, there must have been a lot of things in between, right? From the time wheel was invented to now that we have cars, or from the time that first flying machine was invented by Wright brothers, and now we have flights. So always there is an incremental um, increase in the invention. There'll be some problem in the current problem. Like first there was a difficulty in moving from one place to another by walking for long distance. That is why they created wheels. Now once the wheels are done, what did they do? They attached it to some animal so that you can sit comfortably. Still the problem existed that you cannot travel very long distances with a horse or a bull or some animals like that. And also animals can also suffer from a lot of diseases or problems. So that's where the bicycle started. So unless and until we know, if it is not in the public domain, it will be very difficult for further development. This is the most important thing. But once it is open to the public, you will not get any reward for putting that effort. That is why patents are granted to the invention, which drives the technological progress and gives the market growth. So what are the rights that that a patent owner or a patentee is granted? The patentee is he has exclusive rights to prevent others from making, selling, or using that particular invention, right? And how do we obtain a patent? In order to obtain a patent, an applicant must file an application in the patent office, and depending on the applicable laws of that particular country, the patent office will examine the application and determine whether it meets the criteria of the laws. And then after determining that, after being satisfied that it meets the criteria, it will issue a patent in the name. Okay. And the term for a patent right is 20 years from the date of grant. So after the patent is granted, you have 20 years to yourself. Now, so is that clear to anyone? Should I explain the novelty, inventive, and industrial applicability to, is that required? If anyone, I can just continue. If anyone needs it, I can continue with it. I can expand on that idea. Okay, then I'll move on to the next slide. Now, what are the things that cannot be patented? So we saw what is the criteria of a patentability. So if you have something innovative or if it fulfills the criteria of novelty, if you have a solution which is solution which is either a product or a process. So a patent is either a product or a process which should be novel, and it should be not obvious, or should have an inventive step, and should have industrial capability. But even after that, your patents may not be patented if these are the conditions. Okay, so what cannot be patented? Human genes cannot be patented. Things that already exist in nature, they cannot be patented. Anything that goes against the laws of nature, they cannot be patented. There are certain things that your country, okay, before I continue, I forgot to mention that all these intellectual property rights are territorial rights. So suppose you invent in India and you get a patent in India, but you are not protected in the rest of the other countries. Sorry. So to get your patent, to get your protection for your invention, you have to patent your invention in all the countries, and it has to satisfy the criteria of their particular laws. Okay, so yeah. So where was I? The point number 4, excluded on the grounds of public order or morality. Then there are certain scientific theories or mathematical methods, they cannot be patented. Schemes, rules, methods such as those for doing business or performing purely mental acts or playing games, they cannot be patented. Then methods of medical treatment for humans or animals or diagnostic methods. Please note, these are methods of medical treatment. Now you may think, why cannot methods be patented? Then it will become very difficult for the public to access medical treatment. But what can be patented? If it is a product. So any, like suppose a different variety of stethoscope or some instrument which is necessary for suppose a dental person, a dental doctor. Those products can be patented, but methods of medical treatment, they cannot be patented. Plants and animals other than microorganisms and essentially biological process for production of plants other than non-biological or microbiological process also cannot be patented. So I thought that, like, now whatever I said, it must be all in your imagination, like what is a patent? You know what inventions are, but it may not be clear that what exactly a patent looks like. Because patent is not something that you can see. You can see the invention that you've made. May it be a sound box in a car or your speakers, you can see them, but you can't see what a patent is, because patent is a legal document. So we'll move on to the next slide. This is the simplest patent that I wanted to discuss. Everyone knows about paper clips, right? Is it possible to share this, share my screen, or I'll do one thing. I'll just read from the PDF. So this is the US Patent Office's patent document for the paper clip, which was held by the applicant John Waller. So you can see the diagrams. There is always a diagram. So yes, I'll just read out the important parts which I think was necessary. It writes, so what this is called the specification. What the specification of a patent contains is the description of the patent, why it is inventive, and the most important part of the patent is the claims. I think I've not put the picture of that over here. I'll tell you. And this is the diagram with the help of which you understand what the invention is about. So those are very necessary things. I'll read out the important parts so that you get a better picture about what is written in it. Here it writes, my invention relates to improvements in paper clips or holders, and it consists in forming same of spring material, such as a piece of wire that is bent to a rectangular, triangular, or otherwise shaped hoop. Now, can you understand why it is written rectangular, triangular, or otherwise shaped hoop? Because you cannot say if it did not specify the shape, somebody can say that I prepared a triangular shaped hoop. Does that make it a new invention? It does not. So it, like, so what it does is, like, suppose you have a piece of land. You have a building on one portion and then a garden on one portion, which is slightly publicly accessible. Will you, like, if you don't cover the garden, will you still, will it be possible that that is also not covered under your property? So this is how the specification works. The boundaries, these are the boundaries of your invention. But whatever I'm reading out right now is just the description. Okay. And then it describes the figures. After that, it says the clip described above may preferably used as follows. So it says what is the use of the clips. And then there will be claim. There is just one claim in this invention. I'll just read it out. Or a paper clip or holder comprising the sides or members A, B, C connected by loops D. The side members A and B extending in opposite direction, one inside the other relatively to the side member C, and being not longer than they may be moved around each other inside the loops D. So the claims of a patent is the most important part of the claim patent that defines the boundaries of your patent. So if someone infringes on those boundaries, you can enforce your rights against that person. Right? So are we clear on patents, or is there any doubt? I can take questions on patents if anybody has any doubts. You can write in chat if you're not interested to speak. Please just let me know. Okay. So I'm moving on to the next slide. Okay. So we come to the next intellectual property right, which is copyright. So what does copyright cover? It covers literary, artistic works such as books, music, paintings, films, computer programs, etc. It protects the as again and again, I would like to stress on the fact that ideas are not protected. What is protected is the expression of your ideas. You think of some music or some poems in your head, but that's just an idea. Unless you write it down in the form of a poem or a story, that is something which you have copyright over. There are two kinds of rights which are protected under copyright. One is the economic rights, where you can control reproduction, distribution, public performance, broadcasting, or adaptation. I'll explain all of that. You understand what is reproduction, right? So, I mean, this is the most violated right in copyright, which is also known as piracy, right? So, what we do is that now you may ask that sometimes when we don't have books or we cannot afford certain books, we make a Xerox copy of it. That is violation of the right of the author. But will you be prosecuted for that? No. The reason is you're doing it for your personal use. You're not doing it for commercial uses. So you are not copying it to sell it in the market. So once you take mini copies of those books and sell it to people at a lower price, what you do is you violate the economic right of that author. So that will come under copyright infringement. You copy, and then what you do, you distribute, selling it to the people. So not only, like, now you understand, it's not only distribution. Even if you reproduce, the mere act of taking the book to the Xerox machine and getting a copy of that book is itself an act of violation of the author's copyright. After that, you distribute it. That's also um, uh, that's also a violation. Now, then there is public performance. So suppose I write a poetry, I write some poem, or I create some music. But what happens is uh, you decide to perform it in public without my permission. Then that is a copyright violation. You need to ask my permission and give the credit of the original author. Otherwise, what is the point of me putting so much of effort and my mind and my labor into? There will be no motivation for a person to do innovation. And without innovation, without ideas, it is very difficult to survive, right? Similarly, broadcasting and adaptation are also like economic rights of the author or the copyright owner. What are the moral rights? It's the authorship recognition and the integrity of the work. You don't give credit of the author, or you disparage the original author's work. You make a parody of something without the person's, which is an insult to that person's work or the reputation of the author. That is the violation of moral rights. Now, how do you, like for for patents, we saw that registration is required. You need to file an application at the patent office, and then you are issued a patent. So your invention is registered. In copyright, there is no formal registration required. Once you are created, once it is created, it is protected, right? And the duration of a copyright is 60 years post death of the author or creator, and the 60 years is limited to India. Okay. So yes, as I was discussing, what are the limitations and exceptions? Like all your acts will not come under copyright violation if it is for fair use. So you might be doing a copyright violation. Suppose you Xerox a book. You are already violating the right. But will you be prosecuted for it? No, you will be saved because there is this exception that is, I think the slide got shifted. Yeah. So because you're doing, the purpose of your copying is for, or the purpose of the reproduction is for educational or research purposes, or you're using it for limited copying of personal purposes, right? Even mechanical reproduction is an exception. Like if you write one by one of what is done, that is also comes under the exceptions of copyright violations. Okay, so can we move on to the next slide? Yes. So are you guys familiar with the Bollywood song Be Khayali of Kabir Singh? This is a little search that I did on, I think T-Series. T-Series is the applicant here. So you can see that this title of work, that is Be Khayali or Tera Ban Jaunga of Kabir Singh, has been registered. In the next slide, we'll see under what category it has been registered. You can see on the right side of the screen, I searched for Sanjay Leela Bansali. And you can see that Bajirao Mastani, Hadippa, Guzarish, Gangubai, Ranji Ki Leela Hai Nyari, all of these are registered as copyright. So who is the owner? Who is the applicant? It is Sanjay Leela Bansali who is the applicant, and he is the owner of this work, right? Can we move to the next slide? Here you can see, so the Be Khayali Kabir Singh is the the type of work that the song is a sound recording. Here the applicant name is also Super Cassettes and the author name is also Super Cassettes, that is T series. So there's a difference between applicant name and author name. It is the same with patent and patent also. I'll just explain. So the one who invents it invents a particular invention is the inventor. But sometimes the inventor does not have enough funding to apply for a patent. So who applies? Generally under whom that inventor is working under. Suppose it's a company or a university. So they apply for it. The one who applies for a patent is the owner. But it is important that the inventor's name is also written, which is why we have the author name or the inventor's name in patents. Here, similarly, you have an applicant name and there is an author name. I believe since this sound recording has been recorded by Super Cassettes T series, both the applicant name and author name is the same. Similarly, in Sanjay Leela Bhansali, the type of work is literary or dramatic. Bajirao Mastani is a film, so it comes under literary or dramatic work. And you can see also that this is published and it is not published. Okay, so this is what I wanted to show about copyright. Can we move to the next slide? Yes. So next intellectual property is trademarks. What is a trademark? It is a sign that distinguishes goods or services of one company from another. Okay, so coming to the history of trademarks, they existed in the ancient world as long as 3,000 years ago. And what happened is Indian craftsmen used to engrave their signatures on their artistic creations before sending them to Iran. Later on, over 100 different Roman pottery marks were in use. So you can see that trademarks is not something that is very new. It has, like, they have been used to indicate the source of the product. That is what trademark does, is like you are sure that you are getting the product which you desire to get. Like suppose you want little hearts, or you want, like, you get a car and there is the sign of Hyundai in it. Then you know that Hyundai is, so the car that you have got is the original product of Hyundai. That's what the trademark indicates. Okay. So, and then trademarks, if they have similar sounding names or like Pepsi Cola or Coca Cola, then the common people should be able to distinguish between what is you're taking which product. The product is from the source that you wanted, or it is a different product which is passing off as somebody else's product, right? So what a trademark is actually, it is a sign which is used to distinguish goods or services by one undertaking from those offered by another. And the two main characteristics of a trademark is that it must be distinctive and not deceptive. Distinctive in the sense, suppose, let's say for the example, Apple, right? Everybody knows when I come say Apple, none of like Apple products like iPad or thing, does this anyway relate to Apple as a fruit? No. So it is distinct, it is different. You are selling Apple, which is an electronic product. So for that electronic product, the sign of an apple or the name or the word mark, which is Apple, is distinctive. It is not deceptive. Like suppose I sell leather and I give the mark real leather. That cannot be considered as a trademark. Okay. So that is the basic requirements of a trademark, that it should be distinctive and it should not be deceptive. What are the kinds and signs used at trademark? It can be the words, letters, designs, symbols, packaging, slogans, sounds. If you remember when you start Netflix, you remember that iconic sound? That is the sound trademark of Netflix, right? So there are even colors and smells which can be used as trademark signs. What is the I've discussed already the purpose of trademark, but I'll tell again that first it helps the consumer. So how does it help the consumer? It helps the consumer identify and differentiate between products and services. Then for companies, it enables them to stand out in the market. And also it serves as a tool for building brand image and reputation. Now, can you move on to the next slide? Okay. So how is trademark protected? As we saw, for copyright, there is no registration required. But for patents, registration is required. For trademarks, it's a little ambiguous in the sense that if you have a registered trademark, you get a stronger protection. But if you have an unregistered trademarks, you can gain protection through use and reputation. Suppose you are using a trademark for a long period of time. It has not been registered, but people know you. Like suppose if Haldiram was not word mark Haldiram was not registered as a trademark, but people know Haldiram for its snacks. So it is already known. So in that case, registration of trademarks is not essential. But what happens is that it always comes up in the litigation, and that's where it says that the registered trademarks get a stronger protection over unregistered trademarks. And the evidence required for proving that unregistered trademarks has been used and then it has a reputation is way more difficult, right? And so what are the rights of a trademark holder? They can use the trademark to identify its own goods or services. So use is the first right. They can prevent others from using and marketing the same or similar trademark. And third, they can authorize others to use the trademark by means of franchising or licensing. And unlike copyright and patents, the period of protection is usually 10 years for trademark, but it can be renewed indefinitely on payment of the fees. We can see a few more examples of trademarks on the next slide. If you see here, Flipkart, the one on the complete right is the one that you have always seen. So what was the need for Flipkart to have so many trademarks? So every like Flipkart Home Services, that is a different brand in itself. So Flipkart is an entity which has so many brands, and for each of its brands, it uses different trademarks. Here you can see what is the class. When you see Flipkart Express and Flipkart Home Services, you can see there's a difference in the class. While Flipkart Express has a class 9, Flipkart Home Services has class 37. These classes refers to the classification of goods or services according to the Vienna Convention, right? Here you can also see the validity of each of the trademark, right? Like this Flipkart Smart Buy is valid up to 8/9/2026, and it has been used since 2016. This used since 2016 helps us to defeat other similar trade entities who would like to use who are using similar trademarks, which can be deceptive for the entity who has been using it earlier, right? If you have noticed, you must have seen that when we discussed patent depends on the time that you first invented. So the timeline in patent is very important, that when you invented it. If at the same time two people invented, who gets it registered first is the owner of the of the invention. But in copyright, you can have your origin. Only requirement of a copyright is that it has to be original. It has to be an original work. One can sit in America and write the same poem, exact same poem as the other, but both of their works will be considered original and they are not infringing on each other's right. So that is the reason the registration is required, right? So, but in trademark also, when you start using it is very important. Can we move on to the next slide? I think, yeah. So these are trademarks which have had similar sound, and these have gone to the courts. London Dairy. What London Dairy represents is a premium ice cream brand, and it is known for its logo associated with dairy products. London Dairy is a confectionery line which deals with sweets, chocolates. So what the Bombay High Court ruled is that despite the phonetic similarities, so what is the similarity in these two trademarks? Is do you think that they look similar? Are the trade dress similar? Is the design similar? No, it is phonetically similar. So when we come to similarity, we have to see it in all aspects, whether it looks similar. So that what is the objective of trademark is that the persons or the consumers buying it should not be confused with regard to these things as to what they are buying. Do you think a person who is going to buy ice cream will be confused that it is from London Dairy and not London Dairy, right? Like if London Dairy is chocolate, so there's a clear distinction of the fact that London Dairy is for chocolate and dairy is for the ice cream. So Bombay High Court ruled that visual and product differences were sufficient to avoid consumer confusion, right? Now, PayPal and Paytm. PayPal is the international version and Paytm is an Indian digital wallet. And PayPal alleged that Paytm's logo and color scheme were deceptively similar, potentially causing confusion among users. So do you think you will get confused by PayPal and Paytm? But if you look at it, don't you think they have been Paytm has used similar color scheme for this? So there's a possibility that the consumer might think that Paytm is a branch of PayPal or something like that, right? So this case is still pending in the court, I believe. I don't think the results are out for this. I mean, the decision is out for this. For Nykaa, this is a recent judgment on Nykaa and Oika. The Delhi High Court granted an injunction against Oika to use this their mark because Nykaa and Oika both deal with same products, that is beauty products. And hence it was objected for using this trademark for branding because it might deceive the consumer. So we'll move on to our final thoughts. So these are the three basic like the most important intellectual property which I wanted to discuss because the others will take a lot of time and require a lot more in-depth analysis. And these are the most used especially for innovators and startups. So now to summarize, I'll say that with IPR, innovators get rewarded, their creativity is encouraged, and their trust and brand value is preserved. While so why is it crucial? It is why IPR is crucial. It is, as said earlier, it fuels the economic growth, it secures fair competition, and it enables global scalability. So that is it for my side. If there's any question, something, please, I'm open to questions. You can unmute your mic and ask any questions that you have in mind. Please feel free.
Am I audible?
Yes, sir. Yes, sir.
Uh, well, sometimes I hear,
Yes, sir.
we hear actually that that uh, the program as such cannot be patented, but the program, when embedded in a hardware, the
Yes,
product
yes.
can be patented as a whole. And
Yes, sir. Yes.
there is a confusion around this particular thing. If you
Yes, sir.
some clarification around.
Sir, actually, the clarification still does not exist from the patent office, that it uh, is varying from time to time. We call them computer-related inventions. There is a section 3D which says that computer software cannot be patented. Right, I'll just read out that statement. Just a second. So section 3D says the mere, sorry, it's not 3D, it is, it is 3K, a mathematical or business method or a computer program per se. This per se is where the confusion comes. So computer program per se is not patentable, or even a business method is not patentable. But if it is embedded with hardware, like when you write a patent, you say that it is a product or a process that gives you a better an innovative solution over the previous previous invention which has been in the state of art. In that case, if it is embedded with hardware such as electronic devices or some kind of, like, the app is not uh, the software, the program that is written for an app is not patentable. But if you say that that app is a process to, like, suppose the Flipkart app, so there's a you use that app on a device, that is the mobile or any other hardware devices. In that case, we have to write it in, the patent is written in such a manner that that particular invention can be patented. Because what happens is, computer programs per se, like the code of the computer program, that is already covered under copyright. So we cannot protect the program or the code. But what is the functionality of the code? What does it achieve? And how does it achieve? With the help of which product or which process? Am I clear, sir?
Yeah, that means suppose if I write some codes and create an app, and then while writing, I'll have to write that this is the app which can run only in a mobile phone or in a
Yes.
device or any other similar device. Then that way of writing gives me the patent.
Yes, yes. So you are not claiming anything over the program. You are not claiming anything over the software, in the sense the code.
Code.
What
I
we
am
are
claiming about
claiming,
the app.
yes,
Acha. And the app on its own also cannot be patentable unless I say that it will run on a mobile phone or similar device.
yeah, yes, because otherwise it will indicate towards the software.
Okay, okay, yes, yes. Okay,
Yes,
thank you very much for
yes,
this question. This is very necessary because these kind of questions often come. So good that I got it clarified. Thank you.
yes,
I believe
yes.
now
Like
we can.
I can also elaborate on it if that's okay. Just give me a second. I'll just read out the thing that has been written. There is a CRI guidelines which the patent office has issued, which clarifies that what can be considered as a uh, software or what is not, like what can be patented. I'm trying to find it out. If it's possible, I'll just discuss. Otherwise, we can keep it for some other session. Uh, yes, it says that what is important to judge the substance of claims, taking whole of the claim together. So you have to take all the claims together. I explained what claims are, right? So if any claim in any form, such as method or process, apparatus, system, or device, computer program product, computer readable medium falls under the said excluded categories, such a claim would not be patentable. However, if in substance the claim taken as a whole does not fall in any of the excluded categories, so it has to be taken along with an apparatus, system, device, or it is a computer program product, or it is computer readable medium. Because as we said, invention, like when you patent, it is either a product or a process. You cannot have anything else. Process means a method. You are either like there's a new way of browsing. Like we just open the interface, but how quickly it gets to you, that is a different code. But if we cannot protect that, then it will be difficult. So that is the reason it has to be used with. So as long suppose I write it as a method, then also it will be patentable.
Yeah. Okay. Fine.
Yes.
One more thing.
Yes, sir.
Mm, like when I was writing the claims for my own patents that I
Yes, sir.
did when I was in IIT Kharagpur, I feel that if the technology people like we are not uh,
Hmm.
from the law background,
Hmm.
but I do not know. Do you think that a session on how to write claims
Yes,
would
sir.
be useful for the technology people or other people who are not into legal profession but they want to write the claims? Do you think that is useful?
It can be, but it is a like you don't have to know law to understand patent claims. That is the reason when you appear for a patent agent exam, the minimum qualification are just you should have a background in engineering or a master's in science or MBBS. So anyone can give patent agent exam and can understand how to write the claims. Okay. So
But
yes, that session will definitely be
yeah, yeah.
useful for those interested in patents. So that
My question is, suppose one doesn't want to become the patent agent, but just one, but
it will be
actually,
helpful, definitely. It will be helpful. What
ah,
I will like in my opinion, it will be helpful in the sense that even when you hire a patent agent, it will be
right?
useful for the patent agent to understand
Exactly,
like
exactly.
how to draft your claim so that your
Correct,
invention is covered.
correct.
So
I mean,
that
how?
for that particular reason, yes, to understand how a patent is written, that is useful. But otherwise, uh, since a patent agent is always dealing with a lot of patents and the objections from the patent office, they will be more aware as to how to draft a claim. But
Yeah,
if you
yeah.
so what will be useful for a technology person is
Ah,
that to understand how the claims are structured and what can be written in a claim.
That's it. That's it. That's exactly what my
Yes.
point was. How you brief to the patent agent. How
Yes,
you
sir.
brief, because you were the
Yes.
best informer to the patent agent. So
Yes,
how
yes,
are you informing? Do you think
yes.
a session on that would be useful?
Yes, sir, definitely, definitely.
So that is to view this from the technology person, or say person from other domains,
Yes, sir.
but not from the legal areas, but they should
Yes, sir,
know
yes, sir.
what to write, how to write.
That's what I'm saying. Legal areas is not required for knowing
Ah,
how to draft a claim. That's not a necessity.
okay.
Legal
You
assistance is required only when
would
you.
you be available to talk on that someday?
Yeah, sure, sir, no problem. I just want to know it beforehand a little so that I can prepare better because it's a very
Oh yes, of
complicated
course, of course.
topic.
No,
Yes.
no, no. It will be with your consent only and with
Yes,
ample time. Thank you so
yes,
much
sir.
for kindly agreeing. I mean, it
No,
shows your
it's
academic
my
dedication.
pleasure.
Sure, sure, sure.
Yes,
Thank
sir.
you, thank you. I believe there would maybe other questions or something in the chat box or something.
Yes, there is one, ma'am. Can you compare both terms of patent and copyright? Are you asking about the duration or what are you, the term means definition? You can you can unmute your mic and please let me know what you want to ask.
Yeah, ma'am. If it is, if you define like definition, it will be like helpful.
Okay, the definition, right? So, can you tell me what you understood from what I said right now? Like, it'll be more useful if I understand where the confusion is. What have you understood till now about patent and copyright?
Actually, I have understood that patent is something for my innovation. I have to. It's the legal document of my innovation.
Mm-hmm.
Copyright is
And for
something.
copyright?
There's the thing is not clear actually.
Okay, okay. Can we go to the slides where there is the patent and copyright is there? I'll just explain that. So, when we talk about patent, we are talking about inventions, right? Inventions means it has something to do with solving a problem. In copyright, there is no solving a problem. Copyright is over uh, something that is literature oriented or literary, like the arts, the dance forms, or the choreography, or films, right? I gave example of the films. So the very basic difference is you can see, can your paper clips and a song by Sanjay Leela Bhansali or film by Sanjay Leela, can they be compared? No, right? Because what a paperclip does, it is a physical thing which is solving a problem. It is a technological invention. It is a method or a process. It is a product. So this paperclip is a product. There can be a different processes of suppose waste segregation or waste disposal. That is a process. And what it does is that, so what is the criteria for a patentability is that it has to be new. But copyright, there is no requirement of it being new. It has to be original. That means you have created that source of that piece of art or that work is you. You have not copied it from anyone else, but with copied or worked upon that thing on anyone else, right? It is original. It does not have to be new. You Two people can write the different poems on rain, and you both of them will have copyright. But if paperclip, if there is no difference in the paperclip or if it is not novel or it is not inventive, if two people invent the same paperclip, then you cannot you cannot have patent over it. Am I clear?
Yes, yes,
Or
ma'am.
yeah, or if you have any follow-up questions also, I'm happy to take.
No, clear.
Okay, okay. Any other question? Any other question related to something in the news that you have heard regarding all these three? Are you confused about them coming in the news? I'm happy to clarify.
Jeet, I think now since
Yes, sir.
it is very well articulated the issues, step by step it went with clarification, and also we discussed.
Yes.
So hopefully, if there is some question still, I hope in next time when she is speaking to us, maybe we can raise some more. But for now, I think we can close the session.
Sure. I just would like to ask, sir, like, this is the requirement. I mean, I met the requirement of what you
Wonderful,
wanted to talk about.
absolutely. You were fabulous. I mean, we really, it was very, very helpful. It will actually, I'm sure the students benefited a lot because these kind of discussion is pointed and how, what is the distinction between this and how patent is, what is the usefulness of a patent is and all that. You have covered beautifully, and
Oh,
it
thank
was
you, sir.
excellent. That
Thanks.
was
Like
very,
I was
very,
worried actually. I was not aware
very
like what
informative. It was
is
very
the
informative
audience.
and very interesting.
Yes.
Thank you for accepting our invitation and speaking to
Thank
us.
you, sir.
And
I
we would
hope
love
I
to
did
have
not
you in
disturb
future.
sleep of the students
We,
on a
we, would-
vacation.
we would love to have you in our future programs.
Sure,
Advocate.
sir.
Thank
It
you.
will be my pleasure.
Thank you so much. Thank you. Thank
Uh,
you. Now this is over to you. This is over to you.
Thank you so much, madam, for your insightful and engaging session titled Basic Intellectual Property Rights and it's important for innovators and entrepreneurs. We truly appreciate you sharing your expertise and time with us. I'm sure everyone has gained valuable knowledge from your presentation. Once again, a heartfelt thank you.
Now
Thank you
it's a
so
time
much.
for a vote of thanks. We extend our sincere gratitude to our Honorable Pro-Vice Chancellors, our faculty member, and dedicated teachers for their unwavering guidance, support, and tireless effort in making this academic endeavor a resounding success. Our heartfelt thanks to Professor Dr. Pranav Kedan, sir, and Advocate Manisha Mishra ma'am for delivering a very illuminating lecture section. It would be incomplete if I don't mention about the guidance of Ramyajit sir, Himadri sir, and Deep sir. Without them, this program couldn't have happened the way it has been. Finally, we acknowledge the invaluable contribution of everyone, particularly our ESL colleges, directly or indirectly, who helped make this event memorable. Thank you, and we look forward to see you in our next event.
Thank you so much.
Thank you, ma'am.
Thank
আর কোনো ক্লাস হবে নাকি?